All right, we are back on the record now for the 28th Circuit Court here in Wexford. And we're taking up next the case of People of the State of Michigan versus Jennifer Lee Williams. Appearances?
Nate Carnes on behalf of the people.
Robert Hartzell from Ms. Williams, who joins me to my left here.
Thank you. May be seated. Also here before the court today is Miss Alice Matsky. She's an agent with the Wexford County Community Corrections Program here in the building. We are here today for a contested bond violation hearing. Are we running that hearing still, Mr. Hartel?
No, Your Honor. After conferring with people exactly what the allegations are, I've conferred with my client, and she would do a guilty plea to those.
All right, thank you very much. All right, Ms. Williams, please just raise your hand. Do you swear or affirm the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, thank you. Lower your hand. All right, Ms. Williams, we're here today for a bond violation hearing. We could treat them as contempt, which could get somebody additional jail up to 93 days and or up to $7,500 in fines and costs, but we don't do that. We just treat this as a review of pretrial release conditions. It's and when we have these allegations, you still have the right to some due process, which would mean that we could have the prosecutor put on some witnesses and our evidence, and we could make a determination. I say we, I mean me. You could question or cross-examine those witnesses and present witness evidence or testimony if you chose. However, if you're going to admit to violating your bond, it's not really a guilty plea like a criminal conviction. It's just saying, yep, I didn't do what I was supposed to. The court will consider whether to continue your bond previously as set, modify it, or revoke it. When I say modify it, it can be a change in the amount of the bond, it could increase testing, or other kinds of criteria. You understand?
Yes.
Is anyone forcing you or to make this plea or admission?
No.
All right, so the allegation here is that on August 1st, you failed to appear as ordered for a show cause hearing, and that was itself ordered to address an allegation that you failed to enroll in drug testing. Is it true that you failed to do so, both?
Yes, sir.
Okay. All right, the court takes a look here, takes judicial notice of the terms and conditions of your bond that were previously set while this case was before the 84th District Court, and that was set by Judge Wiggins on or about the 25th of June. All right. Okay, so therefore you're found to be in violation of your bond. So what should we do next with her, Mr. Carnes? Before I do that, let's ask Ms. Mansky. Have you had any contact with Ms. Williams on this file?
No.
All right, thank you. Mr. Carnes?
Thank you, Your Honor. The people are concerned here. This is Ms. Williams' first controlled substance file. It is allegations of possessing meth, which obviously is concerning. And then she was held in jail for probably 10 days. I'm having to do math, so bear with me. Approximately 10 days. Bonded out and then just didn't show up for testing, didn't show up for court. It's very concerning. I think a remand is appropriate given those allegations. She had her shot at bond and just she can be trusted. I think after a cleaning out period, we can see where the case goes from there. Thank you.
Well, listen, I'm going to ask you a couple questions here. Are looking at the felony information, are both counts 1 and 2 both while in the jail?
Yes, Your Honor.
All right.
Yeah, same.
Same day. I just wanted to make sure that she didn't get arrested for one and then taken into the jail and then she still had it on her. That's okay.
You know what, Your Honor, I'm going to have to look back to the police report to answer that question.
Have you done a, do you have any more information on her prior criminal history? I see that she's got this one prior felony for assault resist.
I think there might be 2 misdemeanors. It's not an extensive criminal history.
So she's going to score if convicted, not saying that you are, but just helping understand the likelihood of confinement. Sounds like she scored an intermediate sanction cell with probably 0 to 11, at most 0 to 17. That sound about right, Mr. Hartel?
That's right.
Thank you. while Mr. Carnes is looking up that answer, Mr. Hartel?
Yes, Your Honor, I have conferred with Ms. Williams about the situation.
okay.
It's
Down, well, you can, that doesn't matter. Go ahead, Mr.
all right, and she would, after rehearsing with me a bit to make sure that she wouldn't be saying anything that would, I'd advise against, and stated that she would like to make a statement in a moment, and that would be fine with me to go to the court.
Sure.
What I would say is, she does own up to what happened on bond. She does realize that she didn't do a few things that she should have done, and those are very important things. She does believe there's been some changes in her circumstances. She seems authentic when she speaks with me.
Does she have an address?
What is,
It's, West Falmouth Road. I can't remember the numbers.
West what?
Do you know, it's Falmouth Road. Jake Westor, my boyfriend and I are staying with him. Westor, yeah, Falmouth Road, in Falmouth. I think it's more in McBain.
Is there a difference?
Falmouth Road. Well, you know,
I'm just
they're,
Okay, I got it. I know where all those roads
but
are.
I do.
And I know Mr. Weston. So
I do know that, you know, it's a little bit closer. It's a more stable environment. Even the ladies from CMH said that I looked a lot better. I did know by the point of the date that I got picked up, I did plan on turning myself in. I was just trying to get some things signed up and get my stuff moved over there. And I also, I had a chance to see my son, which I haven't seen my kids in almost 3 years.
Sure.
My daughter's been on and out of different detention centers and somewhere in Michigan, kind of just floating around. And my son's dad, the last time I saw him, he was getting him pizza and never brought him back to me. I had the chance to see my son and I really wanted to see him. And that's how they lied to me. And I was never gonna run. It's not like I would have anywhere to go to because I mean, plus I really want to see my kids and I want to get sober and I want to stay sober. I just haven't had a good living environment to do so. I had the last minute chance of being able to, I thought, see my son. And I wanted to see him before I turned myself in. And
all right. I
and
got
it
it.
wasn't.
Do you
the case.
have transportation to and from?
Yes, I do know.
What do you have?
Well, I don't drive. I personally don't drive, but I have 2 guys that I live with that they can get me to where I need to go. Plus Jake's dad and mom, they live just down the road, so they can also help. I swear
I got it. Tell me.
okay.
It's okay. Just a second. I got to hear something from Mr. Carnes. What's the answer to my question?
Sure. As far as I can tell from this report, she was facing other charges, arrested, and when she was transported to the jail, there was a package weighing 1.2 grams. Weight package together. And that was some other person.
So she was arrested
On unrelated.
unrelated charges, and when they apprehended her, they found meth on her as they were in processing her.
Yes.
Now, I'm told there are new charges in district court.
Yes.
What are those for?
Possession of methamphetamine. I believe there's an R&O as well, but I don't know. That have a lot of complication.
Is that in regard to her being apprehended on this?
Yes, Your Honor.
Okay. All right, got it. Anything else, Mr. Hartel?
the only thing I'd add would be, if I recall correctly, and upon conferring with her, I do believe it's accurate, their bond on that new case is $5,000, I believe so.
I got $50,000 cash surety.
That's probably where that came from, I think.
All right, thank you.
I just asked the court to factor that in. I do believe that she's going to attempt to make that bond, because she did mention that she has resources that she does have to try to help her with that. But obviously, if we remand her here, that would be a moot point.
Got you. Thank you. All right, well, the court takes into consideration Michigan Court Rule 6.106. While I don't make a finding of guilt, the court is allowed to consider under that court rule the likelihood of the conviction, and if she was being searched while going into a jail and being apprehended on a warrant, there's no motion to suppress, and therefore the likelihood of conviction is quite high, at the very least, if not on both charges, at least on the one for possession. Now, if she got arrested again on this bench warrant, and during that search, they did the same thing and found her to be in possession, the likelihood of conviction there is relatively high. The court also recognizes that it gave her the opportunity for testing. She didn't do the testing. I'm supposed to be able to consider those other alternatives, such as testing and monitoring, but I can't do it unless she's there. Court therefore revokes bond, remands to the custody of the Wexford County Jail. All right, let's see if we